All present in the Great Hall, please rise. The Court of Appeals is again in session. Please be seated.
Good morning and welcome again to the Court of Appeals. We appreciate the opportunity to come down to Cedar City and hold oral arguments in this beautiful room and with this amazing student body and everybody else who is with us today. I wanted to make a special thank you to council for coming. I know it's not, especially for you, Mr. Fitzgerald, it might not be a direct drive over from Moab, but we appreciate the fact that you're here and that you will be presenting argument today. Also, just quickly, I would again thank our host, Ryan Paul, the person responsible for the streaming for us and for the audio. That it would be Lee Byers, Kevin Jacobson, who is the chair of the Political Science and Criminal Justice Department here at the university, and Trooper Greenman, sorry, didn't mean to get that wrong. Council is familiar with the way that our clock works. Both sides have 15 minutes in which to make argument on the case. The appellant has the opportunity to reserve some time for rebuttal. As I'm looking at the clock, Mr. Fitzgerald, you are reserving 4 minutes for rebuttal. Wonderful, thank you. And do either of you have any questions about our process or how we are going to proceed? Perfect. Then I would ask, when you're ready to begin, please take the podium, and I would ask that you enter your appearance every time that you do take the podium, because we are streaming. And so just to be familiar with who is talking. Normally we also video, but I don't think that's happening today. So if you just remember every time you take the podium to enter your appearance. You may begin. Thank you.
Andrew Fitzgerald, attorney for the appellant. It is a pleasure to be here today. It is a little bit of a long ways to drive, but we seem to be doing this meeting in this way. And I didn't know, it being October and close to Halloween, that we would be in Harry Potter world.
Right.
I feel like it's Gryffindor and Slytherin here. I'll have to tell my kids it'll be much cheaper to bring them here.
At one point, there was a full-on suit of armor in one of these corners some years ago. I'm sorry it's not here anymore.
That's impressive. They should bring that back. Thank you. This case, I had a similar experience perhaps to this court that doesn't always happen, and that is to read the brief, the opening brief, and have a first impression. I inherited this case partway through, so I didn't write the opening brief. And that's always an interesting experience for me, because typically I'm starting the process from the ground up. This time I was able to sit back and read it. I think there was some jazz music in the background at the time, and probably some other commotion, I'm guessing, in my house. But as I'm reading through, I've had an emotional reaction that I didn't quite expect. And that emotional reaction is based on the fact that I've been a defense attorney for many years, and also I've been a county attorney for approximately 8 years as a prosecutor. And as I read through the facts in the opening brief, I had a moment of shock. And my shock was that prior bad acts, the defendant's or the appellant's criminal history came into the trial. And then it got worse. His attorney called a witness for him that testified about how good he was at the state pen for 10 years. He always obeyed. I mean, generally you do. That shocked me. And then I was shocked again when I saw that there was a 404B motion, a motion to exclude prior criminal history and bad acts to not prejudice the jury, and that it was granted. And then counsel brought all that information in, contrary to their own motion, to the defense's own motion. And then I had to catch my breath again when I saw that the previous gun charge was not bifurcated from the trial. And those are 4 things that defense counsel put into the record that biased and prejudiced Mr. Hunt from having a fair trial.
But you haven't, sorry, I told you I wouldn't.
Can I ask a quick question about the bifurcation, lack of bifurcation, I guess, in this case? So are you saying then it's always ineffective assistance of counsel, it's always deficient performance when counsel fails to seek bifurcation in a case, any case involving a prior conviction like this?
I think giving advice to the college students that are here when they see on a multiple choice test the word always, that's generally the wrong answer. And so, no, I don't think that's always the case.
But doesn't it have to be? I mean, the standard is pretty strict, right? I mean, I guess strict maybe not be the right word, but because I'm thinking of Strickland, but when we look in retrospect, when we examine the performance of counsel, we give them a lot of leeway to make decisions about how they're going to try their case. So wouldn't it always have to be, wouldn't you always have to seek bifurcation to say that in every case, the failure to seek bifurcation is deficient performance?
I don't think it can always be always. I think there are some circumstances where the court will say there was some strategy here and it made sense, and we see results later that that strategy arguably played out. In this particular instance and other instances, it's probably best practice to bifurcate. It's the safest practice. When we have someone who is accused of murdering another person, the stakes are so much higher. And certainly the level of let's err on the side of bifurcation, I think, goes through the roof, which is this case.
Well, notwithstanding your visceral reaction upon reading the blue brief and learning that there was no motion to bifurcate, the fact of the matter is that's not raised as an issue on appeal. We don't have a claim that counsel was ineffective for failure to seek bifurcation. We have other claimed instances of ineffective assistance of counsel, but that's not one of the 3 issues that's identified in the blue brief.
It's not. It certainly could have had more attention. It's brought up in the appellee's brief, and then we certainly followed up on our reply. It's probably one of the more egregious pieces considering this case. And then
But looking at your appeal, we look at the principal brief and what you've identified as ineffective assistance of counsel. And in our first, we have 2 questions. The first is whether it was dilatory of the attorney or something that wasn't objectively reasonable. In other words, an objectively reasonable attorney wouldn't have done this thing. But then the second question we ask is whether it prejudiced the defendant. And in looking at prejudice, we assume a counterfactual world where the case progressed, the trial went forward, taking out that ineffectiveness. Since the bifurcation hasn't been challenged on appeal in determining prejudice, we have to still consider that the bifurcation didn't happen, that evidence was in evidence, and then we assume, with that assumption moving forward, we ask ourselves whether the defendant was prejudiced. So how given the fact that there wasn't a direct challenge in the principal brief on the bifurcation, what do we do with that in that counterfactual analysis?
Well, I think the court can consider it as a cumulative effect of the other claims, and it can consider in the large picture, did this defendant get a fair shot? And certainly bifurcation would have helped. Certainly it wasn't briefed in the opening brief effectively, but it's out there and the court is aware of it, and there's an individual whose constitutional rights have arguably been violated because of it. Add to that, what was argued extensively is bringing in the criminal history. Prior bad acts that he did 10 years of hard time in prison for previous felonies, and that he had a previous gun charge, that he was a good defendant, that he had committed fraud previously. At that point, it's not relevant. There's no strategy that is helpful to bring that in. So
well, we're told otherwise by the state, and I found it rather persuasive, I have to say. Counsel used the prior bad acts. Now, maybe it was well advised, maybe it wasn't, but a sound strategic call, arguably on her part, to say, okay, we're just going to own this. In every single other instance when he was charged with a crime, he admitted wrongdoing, he took responsibility for it. Upstanding citizen that he is, he pled guilty. Every single one of those charges. He never once put the state to the trouble and expense of a trial. In this case, he did. Why? Because in this case, he's not guilty. And you paint that picture, that you may not have done it that way, I wouldn't have done it that way, but it seems like a defensible tactical call to distinguish this history of guilty pleas when he knows he's done wrong from this case here where he's going to put the state to its proof. Take very seriously, ladies and gentlemen, the jury, the fact that in this case he did not plead guilty. Why? Because he's innocent. How is that not a reasonable defense strategy, even though it may not have been one that you or I would have used? So
I've had clients say to me before, Mr. Fitzgerald, Andrew, I take responsibility for what I do. If I did it, I tell you to do it, and we move on. These are, longtime people who are longtime criminals, and so I concede there is a strategy there. In this particular case, I think where the appellee is wrong and where that argument fails is where the defendant, Mr. Hunt, was not arguing that he didn't shoot Mr. Montgomery. He admitted, yeah, I had a shotgun. There's all these reasons, background reasons, and I shot him. So he wasn't denying that he shot the victim. He was denying he was guilty of murder, however, because he claimed he was defending himself in his home. Yeah, he was saying I had other reasons. The problem with that defense is it's a precarious defense because you're admitting you killed somebody, and then that your defense goes to self-defense, how far under duress were you, psychologically, issues we've dealt with before. And that defense becomes very precarious, if not completely destroyed, if your tactic is to bring in previous criminal history and your good behavior at the state penitentiary. He already admitted he killed him.
Do you think it was ineffective assistance to call him as a witness? Or do you think in a case where you're claiming self-defense, isn't it pretty necessary that the defendant take the stand to explain why he did what he did?
I think the witness taking the stand in this particular case is within that tactical reason that the
Okay,
court
well,
would give deference to.
Knowing that he's going to, and this is just going to the fraud charge, knowing that he's going to take the stand, that conviction for fraud's coming in, right? It's a prior felony conviction that involves dishonesty, and the rules say that on cross-examination, the state's going to be able to bring that in. Is that accurate?
I think it's the danger as it comes in. I don't think it's
Well, it's not inadmissible, right?
right. It's not inadmissible. There would be a question whether it would come in, and certainly there would be a fight over it.
Okay.
But it certainly opens the risk for that, of course. And the defendant goes on the stand, and all of this bad information about him comes out. Basically, after I read about his criminal history, my whole thought was he's a jailbird. And it's kind of like if I hand you a resume and I'm applying for a job, and at the bottom of my resume there is a reference, and the reference is the warden at Draper Penitentiary, and the warden says, this individual, he was great for 10 years. He always obeyed the rules at the prison. That point, there's no recovery. You're not getting the job. You can't think of a job that person would get. And so it's similar in that once that bad information, that prior bad acts that only comes in under certain reasons and is restricted by the rule itself for that information to come in, is generally denied. For that to come in, it is so harmful to this case that it can't be anything but ineffective assistance of counsel.
But the information was before the jury because of the failure to bifurcate. That information was there, and the jury knew the J&C was submitted as an exhibit. So I guess ultimately, it seems to me that it comes down to prejudice, because the information was there. The jury knew he had these prior convictions.
It is certainly prejudicial. Its prejudicial value outweighs the probative for certain, and especially considering that his argument was not to deny that he killed the victim. His argument was to say, I had a reason to do it that was different than what you're trying to prove. And so that prejudice, as its effect goes to his defenses, is much more problematic than if he was just trying to say, I didn't do it, I didn't murder anybody.
Can I ask you, I see that you're out of time, but I have a question about the questions about intentional intention. Was it your intention? He acknowledged, given his self-defense or justification defense, he acknowledged that he shot the victim. How is that prejudicial? How is that line of questioning prejudicial then to Mr. Hunt?
Yes, and thanks for asking me about that. That's a little bit of a messy spot in the case with that objection, and then it being sustained, and then again, that information, that term being used again by the prosecutor in almost a flippant way at that point, maybe frustration by the prosecutor. And the thing that bothers me most about that line of questioning was that it was a compound question, and it should have been objected to as compound. And the other part that bothers me, initially it didn't really bother me too much, did you intend to shoot him?
I wanted to ask you about that because the state takes the position that I think that one of the reasons that's not prejudicial is because the court actually got it wrong. It shouldn't have sustained the objection. Mm-hmm. That actually found a bit of resonance with me. I understand that you shouldn't be asking an expert whether under the circumstances you could read somebody's mind that they had the intent. But asking a defendant whether he intended to kill, I don't understand why that wouldn't be fair game.
I have to agree with you. And the judge said at the time on the first objection, I'm just being honest with you, I'm trying to figure this out, I'm not sure, but I'm going to sustain the objection because we don't want to create an error. And so the judge was in the same situation, and certainly I agree with you to some extent. If you look a little further though, and I think that this second issue can tie into the ineffective assistance of counsel, where what took place was there was a question that was asked. The prosecutor asked Hunt, you intentionally pointed the shotgun at Christopher Montgomery and you pulled the trigger intending to kill or seriously wound Christopher Montgomery. Is that true? Defendant said yes before the objection could be noted. Interesting thing about that is really like reading directly out of the jury instructions or the code section for murder one. And if you look at it, so let's say the defense attorney decided, how am I going to counter this? Oh, I'm going to get back up there. I'm going to say, well, didn't you recklessly pull that gun out and you recklessly thought that there was a danger to your life and you were negligent when you pulled that trigger, right? So here we're getting into the jury instructions using the legal terms that I think starts to take that argument for what you and I both thought about to something that starts to look like the jury's fact-finding is getting usurped by strict legalese language. Because you can see at the closing arguments, well, I asked the defendant, did you intentionally do this and did you intentionally do that? And he said yes. So they've sort of trapped the jury and trapped the defendant in that language, which is really just, they're repeating the code. The proper way to have asked that question would have been just eliminate the intentionally. So it would have been said, you pointed the shotgun at Christopher Montgomery, yes or no? Next question, so it's not compound. You pulled the trigger to kill or wound Christopher Montgomery, leaving out the intentionally and the seriously. I think intentionally seems kind of like, well, you can ask someone if they intentionally did something. We agree on that. But when you see in that second part of that compound question that it says, where it says, and you pulled the trigger intending to kill or seriously wound, that's where it becomes a little more of a tell to me, where I'm seeing the prosecution's question is really just quoting almost directly from the statute. And I think the problem with that, it's a subtle argument, but it starts to take it away from the plain facts, and what the jury is instructed to do is to look at the facts and the demeanor and the testimony and make a decision. It starts to turn it into a hyper-technical, well, we use this word and he said that word, and therefore it needs to be a conviction. And so I think initially the judge was onto something in some way. It seemed a little off, but not for the reasons I think initially that we think about. It's this later thing where we see the fact finder, I think, being taken out of the process.
But to be clear, his own testimony wasn't that he accidentally pulled the trigger, right?
Right.
He I won't use the word intended. He meant to pull the trigger.
He did it on purpose.
He did it on purpose. That was his testimony, right?
Yes.
And he said, and I had been trained to shoot center mass, so that's where I shot. So he's shooting a 12-gauge shotgun. He's meaning to pull the trigger from 4 feet away, I think is what the evidence was. And he meant to do it at center mass.
Yes.
That's not in dispute. And we have to take that into account on whether it's prejudicial to use the word intent under those circumstances, right?
Yes. And if you take that consideration, combine it with no bifurcation, combine it with bringing all these prior acts to really prejudice this defendant. I mean, he looked like a jailbird. He looked like, I mean, his reputation was ruined right out of the gates. The jury can't come back from that. When you take those things together, it very much looks like the constitutional rights and a fair trial did not occur. Thank you.
May it please the court, William Haynes for the state of Utah. Hunt received effective assistance of counsel when his attorneys affirmatively used his prior convictions and incarceration after they had already been admitted by the state to advance the defense. And also the trial court reasonably denied the mistrial motion when Hunt was asked to testify about his own mental state. So taking the ineffective assistance claim first, the court should limit its analysis to the claim as it was raised in the opening brief, which did not include a claim that counsel should have moved to bifurcate. And even if you read generously to include an argument that somehow should have kept the state from presenting this evidence, there's no real analysis of that or argument of why counsel was unreasonable. This was an element of the offense that the state had to prove. And once that had already come in the state's case, it was eminently reasonable for counsel then to try to use that evidence that had been admitted to advance the defense. Using the counsel argues that because there was a self-defense claim that's somehow different, but again, the jury had heard about these prior convictions and the prior incarceration, and so counsel there could try to use that to his advantage by arguing, look, every time in the past, my client has accepted responsibility when he's guilty, so now when he's arguing that he was justified, you should believe him, because if he were not justified, he'd admit his guilt. So that's reasonable to make that argument, particularly where the jury has already heard the evidence.
I mean, to a certain extent, 404B isn't even relevant here, right? Because, I mean, you still have to undertake an inquiry about whether it's more prejudicial than probative, just generally, and under 609 as well. But because it's an element of the offense, it's certainly, the reason for admission was not to prove propensity.
That's correct. It was to prove an element of the offense.
Yeah.
And it's extremely probative, but 403 actually does not apply when you're talking about under Rule 609 for impeachment. This court made that clear in Ross. And the only counter argument that defense offers is that Ross is an old case, but precedent doesn't come with an expiration date. And it hasn't been overruled. And although Rule 609 has been amended since then, this particular proportion, the relevant portion of Rule 609, the wording has been changed, the stylistic changes, but the substance is the same. It says that a prior conviction involving a dishonest act or dishonest statement must be admitted. So you don't do the Rule 403 balancing.
What do we do with the fact that it seems a little bit incongruent that a defense attorney files a motion pre-trial to keep out evidence and then puts it in themselves? That doesn't seem logical to me.
That's exactly the scenario that you had in State versus Bedell, where the Utah Supreme Court said that counsel acted reasonably in doing just that. And actually, in Bedell, the trial court had granted the motion to exclude the evidence. And then during trial, counsel changed strategies and decided, I can actually use this to undermine the state's witnesses. So there's a reason for counsel to use the evidence here to, again, to suggest that his client is credible because he's willing to admit guilt when he is guilty. Another important point about this case is that the trial court never granted this 404B motion. The court recognized that the parties had stipulated that they were going to let the conviction come in because he could be impeached when he testified. And because the plan was for the defendant to testify, there was a recognition that this was going to come in anyway. The 404B motion also was not specific about what could and could not, what they were asking to be excluded. It's not clear if it was just these convictions and the incarceration or if there was more out there. But the only thing that did come in was his prior convictions and the incarceration. And that was based on a recognition that the state said, we will impeach you if you take the stand. And Rule 609 made it clear that that was admissible. Counsel also talks about references to his incarceration. Once the jury has heard that he's been convicted, in the average juror's mind, a felony conviction and prison sentence likely go hand in hand. Hearing that he served time in prison isn't going to add much. Also, there was, counsel used that information in cross-examining the father to further this narrative that because Hunt had been to prison, he knew the stakes if he were to grab this gun, and he never would have done that had his life not been threatened. That was the testimony that the father gave, elicited by defense counsel and the prosecutor, and Hunt was able to use that, counsel was able to use that again to further his justification defense. And putting the officer on the stand who had interacted with Hunt in prison, I think this, the analogy that counsel uses of a job application is actually quite relevant. You know, saying you would never put a warden as your reference, saying I knew him in prison, he was a great worker. But if your job application requires you to disclose any prior felony convictions, and you have to already disclose that to your employer, why wouldn't you put the warden on as a reference when that's already in front of your employer? Same thing here, that's already in front of the jury. Why not put the warden, the officer on the stand? And particularly where you have testimony from the state about Hunt's demeanor, his crass comments to officers right after the murder. Counsel reasonably decided, I'm going to counter that with someone who knew him long-term, knew his interactions with law enforcement, and can say that he was respectful, he was respectful and cooperative to authority.
Had a good demeanor, I think was.
And in the moment too,
used.
that night, he transported him from the scene and said he wasn't cracking jokes. You know, his demeanor was different than what was testified to by the other officers. So counsel acted reasonably there, and even if counsel had acted unreasonably in allowing this to come in, it was harmless. The harm that Hunt argues came from this is that the jury thought he was a career criminal and convicted just because of these prior convictions. But the jury returned a split verdict. They acquitted him of the drug charges. Some of his prior convictions were drug charges. If they were just convicting because they thought he's a career criminal, they would have convicted of everything, but they didn't do that. It's also harmless because, again, the jury is going to hear his prior conviction one way or another, but then if counsel does what Hunt says he should have done, they wouldn't have heard counsel's emphasis on his prior acceptance of responsibility. They wouldn't have heard the father's testimony about how Hunt knew the stakes of picking up that gun and never would have done it had he not legitimately felt like his life was in danger. They also wouldn't have heard the officer testify that Hunt was respectful and cooperative. They would have heard no rebuttal to that testimony about his crass jokes to the officers. Turning to the mistrial issue.
To a certain extent, it seems like an ultimate strategy question, right? You have a defendant whose defense is, yes, I shot him, but I was justified in my actions, and who, in order to get that testimony in, has to take the stand. So this all seems ultimately strategic, right? Like, how's the best way to put all this on to give this individual the best defense?
Yes.
And I guess that's going to be my question to Mr. Fitzgerald, not necessarily to you, but.
It is certainly a judgment call that counsel has to make, and particularly once the decision is made for the defendant to testify, which is really the most effective way to present a self-defense claim. And ultimately, that's Hunt's call. So Hunt had decided he was going to take the stand. And once he did that, it was clear to counsel that this evidence was coming in. How to respond to that evidence is the quintessential judgment call that counsel gets to make. If there are no further questions on that issue, I'd like to address the mistrial question. And it's important to remember that granting a mistrial is a dramatic remedy, a drastic remedy that is only appropriate when something is so harmful that it cannot be cured and so significant that the defendant can't be said to have had a fair trial. And that did not happen here for four reasons. First, as the court alluded to with its questioning, Hunt himself testified on direct examination that he shot to kill. It wasn't just that he aimed for centric mass, but when counsel said, "Did you shoot to kill?" Hunt said yes. It's on page 1727 of the record. the prosecutor's questions to Hunt add nothing to that unchallenged testimony. So the court could, affirm based on that alone. The second reason is that, by claiming self-defense, Hunt is necessarily admitting that he intended to shoot, at the very least, and his claim that his statement that he intended to kill, that's not necessarily inherent in a self-defense claim, but it's not inconsistent with it at all. In fact, in some ways, it supports it. It supports definitely the theory that he presented to the jury, that this was an intentional act. I did this on purpose, and I did it because I felt my life was threatened, or my house or my family was threatened. So the court could, affirm for that reason as well. We also have the curative instruction, which Hunt argues that was ineffective because there's no difference between the legal definition and the common definition of an intent. But this court held in Hossman that there is a difference between intentional in the legal parlance and intentional as we use it in the statute. I think it's important as lawyers and judges, we get used to, we live in the criminal law, we live in the world of statutes and definitions, and we're so used to this idea of intent going to the act or intent going to the result. But if you look at the definitions, the dictionary definitions that Hunt provides in his brief, none of those make that distinction. You could take those definitions and apply them either way, but when people speak of intent, they talk about just, did you mean to? Was this on purpose as opposed to on accident? So there is a difference, and the court urged the jury to pay attention to the instructions, to apply the law, that when Hunt says he intended to shoot or intended to kill, that he's testifying about the facts, and it's your job to decide whether that satisfies the legal standard. And then the final reason is that this was admissible, that the court could affirm on that alternative ground that this is something that is admissible. If you think about the import of the defendant's argument, if the defendant is correct, then a defendant could not take the stand and testify that he did not intend to kill, that he did not have the mental state to commit the crime. And that certainly can't be the law. In fact, Rule 704 says that's not the law. It says that a lay witness can testify that the defendant has a particular mental state. The fact that the defendant used the same language in the statute, this court has already recognized simply using language from the statutes doesn't make it a legal conclusion. You have to do more, say, opining that this is my understanding of what the law means, make it clear that you're trying, the witness is testifying about the law rather than about the facts. But Hunt here was testifying about the raw facts of what his own mental state at the time. There is language from, some of the cases this court just last month, the Zimpfer opinion, used the phrase, that it's improper to suggest that a statutory element was satisfied. I think it's important, to take that, interpret that phrase in connection to the rules that they're applying, because the Utah Supreme Court has emphasized that when we're talking about the admission of evidence or the exclusion of evidence, it's the rules of evidence that governs. These phrases from the case law, we need to make sure they're tethered to those rules. So if you think about, did the defendant here suggest that a statutory element was satisfied? Perhaps, but what rule did that violate? If this were an expert who had no personal knowledge, that would certainly violate Rule 702, or an officer of the case who's looking at the evidence and gives his own opinion about the defendant's mental state. That wouldn't be helpful to the jury under Rule 701. But there could be nothing more helpful to the jury than the defendant testifying about what his mental state is. Or if you think about Rule 403, perhaps an expert, that could be more probative, substantially more prejudicial than probative. But again, it's the defendant testifying about his own mental state. You could have nothing more probative than that. And there's no improper basis in the jury relying on that. So for those reasons, the court should affirm the district court's denial of the mistrial motion. And if there are no further questions on that or any other issues, we'd ask the court to affirm. Thank you.
Thank you, Mr. Haynes. Mr. Fitzgerald?
Andrew Fitzgerald on behalf of appellant. There's a belief, I think, in Utah and among other places, certainly southern Utah, that if you're going to break into my house, you might get shot. I think people generally feel like they could defend themselves. It certainly gets much more complex than that if you're an attorney or a judge. It's not quite that simple, and this wasn't quite that simple. But that highlights the issue is that the defendant shot the individual. He never denied it. He said, "I did it," and arguably he said, "I intended to do it," in some roundabout ways. And in that inquiry about, okay, so you did it, no one questions that. Now, is there some justification under the law? Bringing in prior bad acts and then bringing in testimony from the warden, essentially, of your 10-year incarceration and significant details of what put you there, just put you in a very bad act light in front of that jury.
Mr. Haynes' point, if that were true, that the jury was convicting because they thought he was a bad guy and not because he did it or met the elements of the crime charged, why did they acquit on some accounts? I think they have just convicted across the board if it's just because he's a bad guy.
I mean, it's really hard to read the minds when you have such a high charge like that. I think a lot of times jury in their negotiations throw out the small stuff because it's meaningless really at that point. That could be one reason. But I think that he was cast in such a poor light that his defense failed right out of the gates. Why, when there's a rule specifically about not being tried for your previous criminal propensity, and then that rule is very clear. Why would we change that? Why would we enter evidence directly contradictory to that? It would have to be a really good strategy, and it would have to be a strategy that is more likely to succeed than fail. The state mentions the Bedell case. We talked about that in our briefs. Those are very different facts. Arguably, the Bedell case, you can see at the end, Monday night quarterbacking, that it probably was a good strategy. Certainly, we don't have proof of that being a good strategy here. And we certainly, at the beginning, could see that that's not a good strategy. The defendant was so prejudiced by that, was so prejudiced because the jury saw him in such a negative light, they couldn't evaluate his defenses critically and without the influence of those facts getting in the way. And this court is looking to see that fairness and equity and those constitutional rights are protected. I think it was an error, a significant error, to bring that information in and then compound it with the warden or the police officer that knew him for 10 years. The thing that strikes me the most about this is when you're thinking about relevancy and the fact that the defendant admitted essentially the initial facts, all of that, that ineffective assistance of counsel really applies to everything after that. This wasn't a case where the bad facts came in and to try to prove that he didn't do it. And the prosecution, the prosecution certainly wouldn't be allowed to bring in the defendant's criminal history and say, well, look, he did this on this date and this date and this date and this date. They would love to do it. I mean, they argued essentially that that was good strategy, and that's great coming from the state. I appreciate that. But they certainly, under the law, would not have been allowed to do it. So why would the defense be allowed to do it? The only reason if they were allowed to do it is if there's really a significant strategy there that would be helpful, that this court could say, oh yeah, this was definitely beneficial. But I think the majority of the times that someone is bringing in prior bad acts and a police officer to talk about how they were in prison, I think you're going to find that it was prejudicial and that it was ineffective. Thank you.
Thank you, Mr. Fitzgerald. Thank you, Mr. Haynes. We very much appreciate your arguments today. We will take this matter under advisement and render a written decision as soon as we are able. Hopefully that will be soon. And I think that concludes the argument portion of our proceedings today, and the court will now be in recess.
And stay with us for a Q&A session with our judges, so please.
We're taking off our robes to confirm that we're no longer in court.
As I said before, my name is Ryan Paul. I'm a history professor here at SUU, and I direct the A.P.E.X. series, and we're excited to have this opportunity to, for a little bit, to have some questions with our judges, I guess our judges, right? I mean, we're all
your
residents of the state of Utah.
Judges.
So before, we've got a microphone up here, and you're welcome to do that. I just need to let you know, as I've said before, we can't ask any questions specifically about what we just heard for obvious reasons. So before I turn time over to you, can I just ask each of you to briefly introduce yourself and tell us why you do what you do?
Can I ask you if you were in a Shakespeare play here at some point back in the day?
I was not in a Shakespeare play,
You
but I
look
do
like
work
somebody who was.
at the festival. I do orientations and seminars.
That's it.
And yeah.
I've been in on some of your orientation.
Well, I hope they were okay.
They were wonderful.
Thank you.
I had even
I'll put
promoted
that
you-
on my resume, right?
I had promoted you to actor, apparently. They were so
well,
good.
you know, you are the judge, so. So please, if whoever would like to start.
I'll start. My name is Michelle Christensen Forrester. Not only am I the presiding judge of the Utah Court of Appeals, I also have the longest name of any judge on the court. So take that for what it's worth. But
Is mine the shortest?
For sure.
Yeah.
sure, yeah. And that's not even counting my middle name, so we'll make a note of that. I have been on the court for 14, going on 15 years. Before that, I was a trial court judge for 3 years in Salt Lake City in the 3rd District. Before that, some of you have heard this already, before that I was counsel for Governor John Huntsman. And before that, I was a federal prosecutor prosecuting mostly abuse cases, and that was a very hard job. Why do I do what I do? I love my job. I feel like this is one of the greatest jobs. I loved being an attorney, but I really love being an appellate judge. I feel like I get to spend time making decisions that are the right decisions. I get to work with my colleagues in coming up with those decisions. And I get to write, which is something that I love to do.
I'm Dave Mortensen. I've been on the court for 8 years. Prior to that, I was a district court judge for 10. So I've been a judge for 18, been on this court for 8. Prior to that, I was a trial attorney for about 10 years, trying cases all over the state. I even tried a case in Parowan before they quit hearing trials in Parowan. And why I do this? I like to think I might be good at it, but I enjoy it very much. There's a certain satisfaction that comes from taking something that's very complex and sometimes extremely messy and distilling that down to something in writing that can be understood by a wide audience of readers. And that's why I do it.
My name is Gregory Orm. I've been on the Court of Appeals since it was created in 1987. Yes, I was very young by judging standards when I was appointed. For a long time, I was the youngest judge on the court. Somehow, I'm now the oldest judge on the court. It all happened so fast, but I guess it's been something like 37 years. Before I was on the Court of Appeals, I was in private law practice with a civil litigation firm for about 10 years. And before that, I was a law clerk to a Court of Appeals judge. And Why I do what I do now is because by far my most favorite year after I had my law degree in hand was the year I spent with an appellate court judge, helping in a small way for him to decide cases and write up his opinions. At the end of that year, I thought, I really want to do that. Whatever it takes, I want to find myself on a court of appeals. 1987, along came the Court of Appeals. I applied, I got the job, and I've been happy here ever since. At some point, I'll have to retire, but I don't look forward to that nearly as much as I did to being sworn in back in January of 1987.
Thank you. So let's start here. I should remind you that I tell my students whenever we have guests is the number one rule is don't make me look stupid. So don't make me look stupid, and let's ask some questions.
Hi, so is this on? I don't think it's on. Is it?
It's on.
Oh, okay.
Just had to take it out.
Okay. Okay. So my question is kind of a load question. There's like 5 in it, but I got my ballot today to vote, and on the back side is a big list of judges' names and just a yes, no, should they stay or not. And as a college student and just like a basic citizen, I really don't understand what that means. And I want to understand who I'm voting for, what that vote does, and how who's on the court affects me. So my question is, what does the vote do? And how do I know I'm choosing somebody that I agree with, or where can I do that research?
Go for it, Dave.
All right. I'll start with where you can find the information. There, hopefully, somewhere in those materials is indication that you can go to. I think it's judges.utah.gov is the website for the Judicial Performance Evaluation Commission. So we're evaluated by all sorts of folks. We're evaluated by lawyers who appear in front of us. We're evaluated by our court staff, kind of behind the scenes. They can tell you whether we're a tyrant or a nice person. And the lawyers get to weigh in on whether we have the legal skills necessary for the job. And all of that is distilled into a report, and that is available online because the legislature a number of years recognized that you might just be shooting in the dark. Why it matters to you is I'm going to go back to the Declaration of Independence. People don't read the Constitution too much, and they don't read the Declaration of Independence at all. But I'm going to remind you that there was a laundry list of reasons that the colonists were unhappy with the king, and a third of those complaints had to do with the courts. For a while, they suspended jury trials in the colonies. If you wanted a jury trial, you had to go back to England. If the king didn't like what the judge did, the king would just remove the judge. And so when they founded the United States, the founders said, we're going to insulate the judges from that kind of sovereign power. And so independence of the judiciary became the hallmark. Now, there's always tension because judges, to a large extent, are the deliverers of bad news. Our courts have winners, our courts have losers. It turns out in every case, right? And so half the people don't have things turn out the way they like. And in fact, in many cases, divorce cases, for example, nobody likes what we do. Both sides think we got it wrong. One side usually thinks we got more wrong than the other side, but there's that. That matters to you because at some point in your life, likely some legal question is going to arise, whether that exhibits itself in you having to actually go to court, maybe, maybe not. But there can be a lot of circumstances where your life is influenced by the courts. Your life is also influenced by the courts indirectly in thousands of ways. When the law is stable, when the rule of law is predictable, then then society is more peaceful. I'll give you an example. If you enter into a contract and you agree to pay, you get something, a car, for example, and you agree to pay for it. If you don't make your payments, no one here is going to be surprised that they're going to ask you for the money. And that eventually, if you don't, they're going to go to court and they're going to try to get it. Those expectations are set because the laws are set, there's a rule of law, and you anticipate that we're going to enforce it in a fair and orderly manner. If you don't have that, then you get to decide, where is our world if you don't have that rule of law? Well, you're going to do it by mutual combat. That's a bad thing. Most of you aren't very good at sword fighting. Or you're going to do it based upon power. Rich people get to win, period. The poor people always lose. We've had those systems in our history, and that's not the system we have here. And so that does make a difference to you. It makes a difference to your neighbors. Your neighbors, when they have disputes, are going to bring them to court for an orderly manner and not, aren't you happy that there are courts where we don't allow people to talk at the same time and yell at each other? If you're not happy about that, just go turn on the TV and ask yourself, what if what we see on TV on debate is how we ran the courts? Wouldn't that be a sad state of affairs? So, you don't have to have proof to say something on television. You go to court, we're going to make you show us the proof or we're not going to believe what you're telling us. So that's a benefit to the whole society. So I hope that makes you feel warm and fuzzy inside. The reason the judges are on the ballot is judges are appointed in the state of Utah by the governor. That appointment is confirmed by the Senate. If they don't confirm you, you don't become a judge. But once you become a judge, you serve successive terms. For us, it's every 6 years. Us three are not on the ballot this time, but I think all three of us potentially will be on the ballot in 2026. The decision you're making isn't whether we get to be a judge, it's whether we get to stay being a judge. It's called retention. So you decide whether we stay. And again, the information on the internet can probably be pretty helpful in letting you know which way you should vote, one way or the other.
Has anyone been unretained?
Yes.
A couple of times.
Yeah, a couple of times. There's also, I will tell you, I serve in a management capacity in the judiciary. When judges receive bad reports where the commission makes a recommendation, what you're going to see on the back, if you go to that website, is almost all of the judges have a unanimous, yes, you should retain them. What you don't see is the ones that are unanimous, no, you shouldn't. Because those judges, rather than have you tell them they need to leave, they just leave. And so then, since they don't file for retention because they know the bad report is in the pipeline, they're not there. So it serves that function. Does that make sense? That they kind of know? I don't want the public shaming, and so, but there have been 2 examples where judges said, no, I know there's bad news about me, but I'm going to try to stand anyway, and they were voted out by the voters.
And in those cases, people weren't left to somehow dig up this information and figure that out. In both of these cases, there were ads in support of and against the judge. Our Salt Lake newspapers editorialized against the judge. They became very high-profile contests. So the odds of there being a judge on the ballot who deserves a no vote, very unlikely in the absence of that kind of falderall and hue and cry and editorializing and ads back and forth. Those become very high profile.
Hello, judges. My name is Yasmin Koster. I'm a second-year student here at SU, and I'm so happy that you guys are here because last year I went, and it was so much fun, and I asked my boss for time off to be here today, and he was like, what's an appeals court? And I was like, let me tell you, don't worry. Do you want to hear the case last year? It was really fun. But I'm kind of at the point in my academic career where I need to decide what my plans are for grad school. And I guess my question, I'm headed two different ways. My question to you guys is maybe to hear a little bit about what law school was like for you, your experience, and like what kept you interested in it, and maybe what even drove you to get to that position.
How about you start?
Well, ever since I was in fourth grade, I wanted to be a lawyer. It was because I wanted to go into politics, and it had come to my attention back then that a high percentage, this has changed a little bit, but back in the day, a high percentage of politicians had law degrees. I got over that long before law school. I decided I did not want to have to campaign for a job that I may or may not get. But that idea that I wanted to become a lawyer stuck with me. So when I went to college at the University of Utah, my undergraduate work was in history, English, and political science. I thought those were subjects that might position me well for law school. I got really good grades so that I would be credible, and it was a really good idea. I got really good grades because I bombed the LSAT score, so I needed those grades to make me a credible candidate. But I think law is a nice career. There are a lot of things you can do with a law degree, short of being a trial attorney. You can work in-house with a corporation. That's one of the qualifying degrees to enter the FBI Academy. You can teach law. I think a law degree is not as limiting a career choice as people sometimes think. It actually keeps a lot of options open for you. I quite liked law school. My first year, not so much. It took me a while to kind of get the hang of it. But I hit my stride after first year and really liked second and third year. And as sick as twisted as this will sound, was kind of sad that there wasn't a fourth year.
And unlike Judge Orm, I didn't know that I wanted to go to law school until I was a senior in college. I was a history major in college, and I loved the reading and writing and analyzing. And then I had a decision at the beginning of my senior year. What am I going to do after? You know, there's not a lot of people or a lot of companies that want history majors on there as their staff to practice history. So I had to decide what I was going to do with my degree, and the options were to continue to go on to graduate school or, you know, law school. That's a possibility as well. I'm very happy that I chose the law school route. I loved law school. I loved every bit of it, actually, all 3 years. I loved the learning. I loved, as Judge Mortensen mentioned, just the stability and that there are set rules. That really works well with my personality. I have not had 1 minute of regret. I think you have to decide sort of what feeds your soul, what do you want to do with the rest of your life, right? And if you enjoy learning, there are so many laws and there are so many areas of the law that sure, you could specialize in one particular area, but you can also know that throughout your career, especially being a judge, you get to continually learn about everything. And that has been very fascinating and enjoyable for me.
And I'm right in between the two. I had no visions as a youngster or an adolescent of being a judge, but once I got into college, I started thinking to myself, where is this going? And so it was a process of elimination. I was an English major. I loved to read and write, and just looked at the horizon and thought, oh, that law looks great. Jerry Seinfeld says that the reason people hate lawyers is because they're the only ones who read the rules on the top of the box of the game of life. I think that's true to a little extent. I like knowing what the rules are and the complexity of the law, and I've never regretted the decision. It's been a fun and interesting career, and it's always new, especially on the court. we keep splitting hairs. I mean, the one thing about the Court of Appeals as opposed to trial court is when we write up our decisions, they become precedent. They are the law of Utah until either the Utah Supreme Court reverses us, which they do on occasion, or the legislature changes the law, because they're free to do their thing. And that's okay with us too. We're just to tell you what the law is today, not what it should be tomorrow. And so that's been a real fun part. But the actual cases are as diversified as there are a number of people in Utah. So there's whatever it is, approaching 4 million people in the state doing stuff every day. Some of it's not quite legal. And so that gives us, a job.
I'm going to interrupt just long enough to say, we have nifty little souvenirs. These are gavel pencils. 2 erasers, and the erasers work nicely. They say Utah State Courts, provide the website here, and at the conclusion of the Q&A, we will set these right on a chair, right by where you are. Yes, they're going to be in your chair when you get up. Please come and take a pencil or two. We've got more of them back home. I don't want to go back with a box full of pencils, so help yourselves when our proceeding here concludes.
So what I'm really hearing you say is that if you want to be a good citizen and a good human being, history is the thing you should study.
Maybe so.
Thus saith the judges. Thus saith the All right.
English.
Yeah, or English. Yeah. Minor in English, major in history.
Yeah.
Right. There we go. So very quickly, I know some of you have class. Kaysen, can you ask your question? Speed round, and then we'll be done.
All right. Hi. So I've come to live court the last couple of years, and I've noticed a different set of judges every time. I know there's 7 of you on the Court of Appeals. Mm-hmm. So I'm just curious the process how you 3 are selected out of the 7 to come here. Is that something you like fight over? Do you draw straws and you 3 just drew the short straw this time around? How does that work?
Definitely not the short straw.
That's a really good question.
It is. Actually, our panels are set randomly. Basically, the cases are assigned randomly. The panels, there's only various setups that they can do, right? Because there's only 7 judges and we sit in panels of 3. But this is, if they're looking for volunteers who might be available to sit on a panel such as this, it is, we fight about it.
No, we like to come down here.
We like to come down here.
And not every single time, but more often than not, Judge Orm will be on the panel here. I don't know if you've noticed that continuity, but
I did miss the last 2 years, but before that I had come every single time, and I had always been the chair of the panel. A historical reason for that, back when Mike Benson was the president here, he and I hatched the idea that the court, when the new moot courtroom was built, Mike said, I wish the Court of Appeals would come down to our campus and hear cases. And I said, we can make that happen. So I don't want to, it was kind of in joint effort with President Benson, was kind of my baby. I'd been a big fan, as you heard earlier, of the Shakespeare Festival, loved to come to Cedar City, loved to have dinner at Milt's. So yeah, I kind of held on to this for a while. And about 3 years ago, I decided, okay, this can't be the Orm monopoly anymore. Orm monopoly. I walked away from it for 2 or 3 years and haven't been down in a while. And now that I'm back, I'm not the chair. I can live with that. But it's definitely nice to be back.
Okay. Before we thank our judges, we need to, if you would please, with a round of applause, recognize the person that makes really all of this happen, the court clerk, Jennifer Gadwa. Please give her a round of applause. She is, if you've been on it's a small world at Disneyland, there's the river that moves you around, and if you get stuck and just hear that's terrifying. She's the river that makes us this small world go around.
Wow.
So, and one last thing, they don't get this often. Please, if you would, give a round of applause to our judges. And thanks for coming to Apex. I'll bring the pencils down and have a good one, everyone. Thank you.
Thank you very much.
Thanks so much.